In the webinar, this is the end of our 7th year of giving these webinars. Of course, it's a different presentation when we're doing it remotely as compared with when we were doing it in our offices, but we hope that the message, the value that we bring will be as well accepted in one form or another. Just a brief overview of what we're going to do today. We're going to have as our first hot topic a discussion by Ken Jull from our corporate litigation area of the firm. Ken is an expert both as a professor and a counsel and an advisor to government on corporate governance. And he'll tell us about some of the newest changes evolving within the corporate sector, to a great extent driven by jurisprudence, but also public issues. Then I'm going to talk about a number of the tax changes that are being promoted and changed worldwide, promoted by the OECD, and Canada seems to be going along with many of them. And I'm going to suggest a number of them are less than ideal proposed changes, but we need to be aware of them. And then our next speaker is Heather Zordel from our Corporate Securities group. And as part of what we're trying to do in these seminars, not focusing on one particular area, but covering important areas within the firm, Heather is an expert in securities law and the regulatory regime, and will be telling us about some new legislation, particularly in Ontario, that updates the Securities Act, which has, I guess, Heather, not undergone significant change, even though it's been public's been clamoring for it. This is the first change in many years. And then our final speakers are a combination of Lindsay Histrop, who's the head of our estates group and whom you all know has been the co-chair with me of these 7-year presentations, and one of our new articling students, Parish Bhumgara. They'll be talking about digital assets, particularly from the point of view of how to manage planning for estates. We've had a previous presentation where we introduced the topic. This will go into updates, particularly with developments with Bitcoin and other international measures, and how one can look after oneself and one's clients to better protect against lost assets on death. So with that introduction, I'm looking to see if Ken has joined us, but it doesn't look like he has. So why don't I begin then? The discussion of the OECD global tax reform. And if I can be the host, that I'll be able to see where the presentation is. Oops. So Saad, you want to make the presentation available to me, and then I can share the screen.
Saad went over to Parish, so muted.
Oh. Okay. I actually don't.
Saltman, just tell him that. Sorry, Nixon was here.
Well, while we're waiting for the screen to be made available. I'll just start. What I want to talk about is the domestic and international tax changes being proposed this year that are far-reaching, and not many people are aware of them. They impinge on not only multinationals, very large corporations, some of which are Canadian-based, others that are foreign, but they have significant operations in Canada, but also for individuals. And in particular, I want to draw attention to the new rules for beneficial ownership and how the OECD is pushing for transparency. And then I'm going to talk about what's happening in the world when we look at the Amazons and the Googles that are huge US-based companies generating a tremendous amount of revenue and wealth and power and a great, I'm going to suggest, resentment that the revenues are not being taxed in high tax jurisdictions, particularly Europe, and a number of countries have introduced digital services taxes, which we'll talk about, including a proposal for Canada to do so. And then at the end, I'm going to talk about the OECD's initiative, Base Erosion and Profit Shifting, or BEPS for short, and how, in particular this fall, two very significant changes were approved, and Canada is at the forefront of them, to revise significantly international tax rules and then impose a global minimum tax. There we go. Thank you. Okay, so there's my initial introduction. And I'm having a little trouble moving to the next slide. For some reason, I can't move to the next slide. But I'll talk about it. Beneficial ownership transparency is the next slide. Under the current Canada Business Corporations Act, there is a right. Well, first, there's an obligation to maintain beneficial ownership, basically, not public, but private companies. Anybody who has a 25% position to be able to control the corporation has to be declared. But right now, that's information that's available to the director, a federal government official under the Canada Business Corporations Act, a shareholder of the company, a creditor of the company, so long as they are seeking that information to use it for any matter related to the affairs of the corporation. It is not available to the general public. However, that is something that we are going to be looking at as a major change, because the federal budget this year in April announced support for the Department of Innovation, Science, and Economic Development for the implementation of a publicly accessible corporate beneficial ownership registry by 2025. So think about the implications of that. I'll just come back to that in a moment. Ontario announced in its spring budget that it was also going to require disclosure of beneficial ownership, but in the limited way that the CBCA has now, not to the general public. So the federal government is going to open it up broadly, but Ontario will keep in mind privacy concerns. And I emphasize that because in this movement internationally to combat what is described as tax evaders and drug dealers hiding behind corporations as shells, there is a legitimate concern that regulatory authorities should be able to know about those corporations. But very briefly, the OECD in itself betrayed what's really happening here. An example was given where a corporation pays full tax in its jurisdiction of residence, but nevertheless, there should be a requirement for beneficial ownership of that compliant corporation to be disclosed publicly, because there could be evasion, there could be drug dealing and so on going on. In other words, the income tax system is now being distorted and being used as a tool to get into many other areas. Question whether there are privacy protections. Can someone take advantage of a part of these new statutes to say, that's not fair, appropriate, my family's exposed by that public information? Nothing like that in Canada. Some European countries like France and Switzerland have introduced those kinds of protections. We don't have it. So a red flag to watch for. If I can go to the next slide, but it doesn't seem to be going. Well, my next slide is digital services taxes. And here, as I mentioned earlier, the driver is the desire to capture some of the international revenue generated primarily by big US multinationals. There are others from China and Europe, but they don't play as prominent a role. And so initially, the United States was very much against this whole notion of a digital services tax, because traditional international tax rules would say a country like France can't impose tax on Google except if there is a permanent establishment of Google in France. Under the new rules, that won't be necessary. 3% of gross revenue determined by French rules as derived from France will be subject to tax. Well, there could be other countries like the United States will say, wait a minute, we have different rules. There's going to be double taxation on these large companies. And the digital services taxes have sprung up in several jurisdictions around the world: India, UK, Germany, Spain, Austria, France, and Canada has announced that it's going to go ahead with a digital services tax unless the OECD comes up with a better way, which I'll come to shortly. In the slides, which you and the audience can get afterwards, and I don't have time to go through all of them, I indicate which particular areas Canada says they're going to impose tax on foreign corporations that generate gross revenue from Canadian consumers. Now, to counter that proliferation of digital services taxes and the possibility of double and even triple taxation problems and the constraining of international commerce, the OECD has promulgated under its BEPS projects, both base erosion and profit shifting, an approach that revolutionizes international taxation under two headings, Pillar 1 and Pillar 2. Under Pillar 1, there would be a new profit allocation and the determination of when does an international corporation have a close enough nexus or connection to a country in order to give jurisdiction to tax to that country. So generally, this amount A has to arise because the multinational has turnover of over 20 billion euros, profitability above 10%, and in the particular country, let's call it the market jurisdiction, where consumers use the digital facility, there has to be at least €1 million generated. In that case, then the residual profit, the profit above the 10%, would be taxed at a rate of 25%, were allocated to the relevant market jurisdiction. But you can imagine that if you've got an international company, let's say, broadcasting digital information to the 26 members of the European Union, several of them may say we have a right to tax even if it crosses over other borders. So I can foresee a number of controversies coming up. That's amount A. Amount B, and it just before I turn from that, that at least has a principled basis for imposing a new international tax rule. It's formula based. It looks at overall revenue and locally derived revenue. That makes some sense from a tax policy point of view. But amount B is a little more difficult. Generally, in the international context, we have transfer pricing rules, which impose on non-arm's length parties who deal with each other cross-border to have goods and services sold at prices equivalent to what arm's length parties would pay. But it's proved to be difficult in the digital age because so many of these digital services are unique to a particular company. And so amount B tries to address that by saying that there's now a consensus among 141 countries around the world to impose a 15% corporate minimum tax on multinationals that have annual revenues of at least 750 million euros. So if we look at a Canadian parent corporation that is that large, and it's faced with a regular 26.5% tax, there would be an additional 15% tax payable in Canada if a foreign affiliate pays tax at less than 15%. Take a country like Barbados, a country with which we have a tax treaty, and the regular corporate tax is 5.5%. So that would be recognized as a credit, and the corporate minimum tax addition would be 9.5% to the 26.5%. So a little bit of a justification. Why does the OECD say this is necessary? It's because there has been a race to the bottom, they allege. In other words, corporate tax rates around the world are falling. Governments have to pay for the pandemic, and really going back to the crisis in 2018, that is still a hangover, and we need to bring in higher corporate taxes. But the interesting thing is the OECD's own statistics belie that assumption. Corporate tax revenues increased from 12.3% of total revenue in 2000 to 15.3% in 2018. That's across the OECD. As well, corporate taxes collected as a percentage of gross domestic product, again across the OECD, have increased from 2.7% to 3.2%. In other words, there's a gain of 20% instead of a loss. There is no race to the bottom. The justification for this tax is, I'm going to suggest, maybe politically incorrect, it's soak the rich. These companies, particularly American, are targets, and Canada and other countries are going after them to grab revenue without I'm going to suggest a proper tax policy justification. Canada's, and I'm going to end with just this little sermon. I started my career in the tax policy branch of the Department of Finance. For over 40 years, the policy for Canada has been to encourage Canadian businesses to expand abroad, making decisions based on good business decisions, reduce tax barriers, have the Canadian landscape, domestic and international, be flat. And so if a Canadian company wanted to expand from Ontario to Alberta, or from Ontario to the United States, or one of the other 100 countries around the world where we have tax treaties, they should be able to do that without facing adverse tax consequences. Now, a Canadian company is going to have to think about this 15% minimum tax that they're facing if they set up a foreign affiliate in a country where previously they were encouraged to set up an active business. A hotel in the Caribbean, for example, now will be very negative from an expansion point of view. And I would suggest this is not good for our Canadian multinationals. It's not good for our Canadian economy. And I think it's extremely bad policy. Okay, that's my little spiel. Ken, I took your place, but now if you could please give us your presentation on the new corporate governance rules.
Yes, thank you, Lorne. Let me just make sure that everybody can see this screen. So Lorne, can you see my screen that says
Yes.
new model based on corporate reputation?
Yes, perfect.
Very good. So thank you very much, Lorne. It was always a pleasure just to listen to your, I won't say rant, I think considered careful analysis of the new proposals. What I want to talk about today is it's a case that's in the Supreme Court came from the Supreme Court of Canada that basically said that corporations cannot avail themselves of the rights under the Charter with respect to cruel and unusual punishment. In other words, corporations cannot say a punishment was cruel and unusual against them such that it would be struck down under the Charter. And as a setup for understanding this, I want to just step back and do a quick refresher about how corporations are criminally liable in the first place, because you have to understand that. This is a slide that's an excerpt from my text where we talk about just a very basic model that we all know about of corporate liability, which is a limited liability model where the directors act in the best interests of the corporation. In Canada, we have a hybrid criminal law model that's somewhat between the United Kingdom and the United States. In the United States, there's basically vicarious liability for the acts of individuals that can lead to criminal liability of a corporation. In the UK, it's more centered on the directing mind. And we in Canada have, as typical, a hybrid compromise where criminal liability focuses on the actions of a senior officer, and that can include middle managers of the company. And so you have different levels of corporate criminal liability. That's the criminal code liability. You can also have regulatory liability for a corporation, which is a different test because it's provincial and it's based on primary responsibility, care and control. And then there's administrative monetary penalties. So just as an example of a case which illustrates corporate criminal liability in Canada, the Global Fuels case was a price fixing case where the territory managers of Global Fuels were colluding with and price fixing the price of gas. Just imagine that, who would imagine? And they were fixing the price of gas with the competitors. What was important about this case was the evidence was clear that the senior vice president at the C-suite were not aware. There was certainly no evidence that they were aware of this price fixing. But the regional manager was aware of what the territory managers were doing. And that was enough to find the corporation to be criminally liable for the offense of price fixing. Another example is SNC-Lavalin that we've just seen in the news, where senior officers such as Bababwe bound the company. Okay, so that's the background. That brings me to this case, Supreme Court of Canada decision in Quebec versus this numbered company. And what, as I said, they've unanimously said Section 12 of the Charter of Rights and Freedoms does not protect corporations from cruel and unusual punishment or treatment. And it really comes down to the word cruel. And they said this does not apply to human beings. Cruel, they said, denotes human pain and suffering, either physical or mental. A corporation, as we've just seen, can be convicted of a criminal offense, but it's a non-human entity. And so therefore, even though it can be convicted of a criminal offense, put on probation, given a very large fine, as we saw in SNC-Lavalin, 280 million, it can't be subject to human pain and suffering. So that's the essence of this decision. And it's interesting, if you look at the facts, it was a regulatory case where this company was found guilty of carrying out construction work without a proper license, so classic regulatory offense. And under that legislative scheme, the Court of Quebec imposed a mandatory minimum fine. Now, it doesn't seem like a lot of money in this case, but the point here was it was a mandatory minimum. And these have been falling to constitutional challenge in some cases where individuals were imposed a mandatory minimum fine. And so the corporation said, well, let's try that out. I mean, if individuals are able to strike these down as cruel and unusual, maybe we should too. So they challenged this mandatory minimum fine. And that's where the court says, no, you can't do that. Now, there's some of the language is interesting. They've left the door open, I think, very narrowly with the following expression. The court says excessive fines, which a corporation can sustain. It's an interesting turn of phrase when you think about it. The fine, even if it was excessive, which a corporation can sustain without more, are not unconstitutional. So what does that mean? I mean, it means there's got to be maybe something out there that would potentially create a situation where it could be cruel and unusual. It's very odd language. And what they basically said is for Section 12 to be triggered, fines would have to be incredibly excessive to be abhorrent or intolerable, such that it would be anchored in human dignity. So maybe the door is open a little bit. Now, what I wanted to talk about, we talked about in the book, was that may be quite applicable if you've got a very large company, like you think about, IBM or Facebook or Apple. But what about a small, closely held corporation? And we started thinking about that. So we were thinking about, in the context of a small, is there a possibility of what we call a reverse piercing? Because one worries about it being unfair. If you have a small corporation, and I'm going to give an example in a moment, that the result is it impacts a few shareholders, and their corporation can't make a challenge, that may be as problematic. So we started thinking about, well, let's think about veil piercing. Now, generally speaking, corporations, the courts can't pierce their veil, with one major exception. If corporations are engaged in fraudulent or improper conduct, typically the classic examples are stripping their assets out in a fraudulent way to avoid, for example, a regulatory fine, a court can step in and say that is improper and will pierce the veil. And that test has been recently affirmed in the Chevron Corporation case. You have to show fraud or improper conduct. Now, one of the interesting things is when governments do this, governments will bring action sometimes where they feel that there's been improper conduct. And when there's academic literature, I cite an article here that said when governments bring a veil piercing, they are successful 45% of the time. And that is a huge success rate, which shows that the courts are sensitive to this. So we thought, well, we understand that if a large corporation is hiding its assets and acting in a very improper way, the government could pierce a veil. But let's imagine the reverse situation. So imagine you have a family-run business, and let's say there's 3 people, and they have incorporated their company, and they've poured their life savings into it. Let's just say, for the sake of argument, they're newcomers to business worlds. They're not sophisticated, and they get caught up in a quasi-criminal regulatory offense, very much like not having a license, for example, as you saw in the Quebec case. And let's say, because I'm a law professor part-time, I use these examples to illustrate the point, but for the sake of argument, let's say they get fined $1 million. Now, in that case, that's $330,000 each, which could be their life savings and could lead to the loss of their house. Here's the Supreme Court of Canada, though, it says, well, too bad, but you can't challenge that because you're a corporation. What we think is that should be open to an argument that there could be a reverse, what we call a reverse piercing. In other words, where it would lead to cruel and unusual results for the individuals who are the shareholders in this case, then there could be a reverse piercing. Now, keep in mind, the general rule is, of course, you don't pierce the corporate veil, and limited liability doesn't do that and allow for that. So this would be a very unique circumstance, but we think it might be appropriate where there is a potential injustice, where you have a very small, closely held corporation. And so that's some of the thing. That's one of the things we think coming out of this case. I want to end just on one last concept, which is kind of fun. There's a lot of talk in today's day and age about corporate reputation, and corporate reputation is obviously very important. And one of my favorite examples of this is, you may remember, or you may not remember, this goes back about 10, 15 years ago, an IKEA commercial. And what it showed was this little lamp being tossed on the street by its owner, and it's out in the rain, and you feel sorry for this lamp. There's a picture of it from the commercial, and it really tugs at your heartstrings, this poor little lamp that's out there. Until a Swedish actor, because it's an IKEA commercial, comes on screen and he says, many of you feel bad for this lamp. That's because you're crazy. It has no feelings, and the new one is much better. And it was at the time, people thought this was pretty funny. But here's what's interesting. Fast forward to where we live today, and the age we live in today, where corporate reputation is so much more important, and corporate social responsibility and ESG is so much more important. Now, IKEA's released the Lamp 2 ad, and in this ad, the lamp finds a home, and it finds a home with this little child who takes it in off the street. And then the Swedish actor, it's the same guy, comes out and he says, maybe it's not so crazy to reuse things. So I'm going to end on this. As we go forward into this new world where corporate reputation is so much more important, and we think, and we've got courts saying, well, you can't treat a corporation in a cruel and unusual fashion. Maybe we need to rethink some of our corporate paradigms, because as corporations become more human in their reputation, maybe we need to be thinking about different models. And that is a topic for another day, involving fundamental governance issues that I don't have time to do or talk about today, but I hope that this was a thought-provoking presentation for you to think about. And with that, I'll hopefully, if I can.
Yeah, it's over to Heather now.
Sharing, and there we go. So thank you.
Heather, it's over to you.
Okay, can I turn my voice on? Great. Lorne, you should be able to hear me now. Can you hear me?
Yes, perfectly.
Okay, great, thanks. All right, so today we're talking about changes to the Securities Act, just to give you an update on where we are on that. because we have a request for comments that's come out, and about a full-fledged wholesale change of the act. Not going to just amend it, we're going to throw it out and bring in something new. So I want to just give you a little update. That doesn't mean that there's a lot of changes necessarily in it coming from that consequence, but there will be changes coming from other things as well. So I wanted to, the Securities Act is supposed to be set up so that originally was done years ago, that they would do a review of it every 5 years. And so I actually have a copy. Oh, don't have a screen. So I can't show you. I can't see myself. There we go. But anyway, 5-year review to review the Securities Act was done in May 2002. And we haven't really had a 5-year committee since then. But we did have a process where we went through, there's been various things that have been looked at separately. We did do a proposal for a national securities regulator. I've got the report on that too. Now it's 10 years old, done in 2009. I was involved with that project. And now we have a review that was done by Waleed Solomon and his group that just completed a review earlier this year, this year, yes, and has made proposals. And now what we have had is a piece of securities legislation that was passed here just a few months ago that has created a schedule to replace certain things in the Securities Act. And then following on the heels of that, we have further changes to be made. So just to briefly go over what's going on, the Securities Act 2021 has been put through, and that is allowing for 3 basically major things to happen. One is to change the governments of the Ontario Securities Commission. And it is, yeah, we're not getting to your slides, so you're good on, stay with number 1 there. We're changing the Securities Act to provide for 3 major things as far as I would suggest. One is to separate the role of the chair and the CEO, which is important because that's what we do for public companies. General governance is to have a separate chair of the board and CEO. And so that's been a long time coming. That is now going through. And in fact, humorously, today, I just got a copy of the advertisement that has been posted by the Ontario Securities Commission to separate the chair, the CEO role. So they're advertising, not to separate, but the result of that is that they have to hire one because we have a chair of the board, and right now the chair of the board at the OSC is also the CEO. So they put out an ad now to, in case anybody's interested in applying. The Ontario Securities Commission is an independent group here, is dealing with exercising regulatory oversight. The mandate of the OSC is to provide protection for investors, all this stuff. You're probably familiar with that. In February, the Ontario government appointed a capital markets modernization task force. That was Waleed Solomon's. And one of the key recommendations was to separate the combined chair and CEO position into 2 distinct positions, a new full-time CEO position to manage the organization and oversee the regulatory function, and a new chief adjudicator who will direct the operations of the tribunal. So the second piece of this is right now, the tribunal members of the Ontario Securities Commission are also the board members. And the problem that is a challenging role to have both those roles at the same time. It's also not the way we're managing modern tribunals in that we, so for example, I'm also chair of the Condominium Authority of Ontario, which is a sort of a similar model, but the new model, you have a separate chair from the CEO, and then you have 2 streams. One is your board stream, one is your tribunal stream. And it really changes the way you look at your board members and versus your tribunal members. It's a specialized tribunal we run at the Condo Authority. And so it's separate, and it's got a separate chief adjudicator as we're now going to have for the OSC. And then they go and hire people who are specifically picked for the tribunal experience and for the balancing of the experience you need for different types of cases there. that's what we're now going to do with the Ontario Securities Commission. So looking forward to that. But first, we're hiring the CEO and getting that mission taken care of. And so that's been approved and is going forward. The Securities Act changes are going forward to separate out the tribunal as well. And so they're looking for board members and looking for tribunal members will be coming up after that. But today we're announcing today or yesterday came out, I guess, the applications for the CEO position, and those applications are encouraged by December the 17th. So take a look if you're interested in that job. Now, moving on to what we came to talk about today is the next piece of what's going on, which is a Capital Markets Modernization Task Force report results. We're coming now to the slides here, beginning, yeah. And we're going to talk about the next piece that's coming out, which is the proposed replacement of the Ontario Securities Act, covering it in a bunch of different groups. And we've got 90 slides that are coming to you on this. I'm not going to go over every single one of them. What is happening here, and this is the third piece of what's coming out of that Securities Act change, is we are replacing the entire Securities Act with what is effectively a provincialized version of the National Securities Act that had been drafted previously for the National Act. So that's been worked on for a number of years by a separate organization that was still trying to move forward with getting that enacted. But now we've sort of given up on that point and we're adopting it as a provincial piece of legislation. And so it had to be, why? Because it's a modern act. It's a whole new act. It's not based on all the other little changes that we've made in the other ones going along. And what it does is it provides sort of a platform legislation that will allow other jurisdictions, if they want to authorize the Ontario Securities Commission to be responsible for securities legislation in other jurisdictions. But that's not a piece of what we're dealing with right now. We're just working on trying to get the act done. So these are the first 7 things we're looking at. What we're doing is my colleague Eliana has given you a lot of detail on slides so that you can take that away. And it just helps you to navigate it because it's different. And it'll help you get through if you're taking a look at this. So we've got the first 7, we've got background, we've got the Securities Commission Act 2021, that's what I was just speaking about. We've got an overview of the CMA, we've got new approaches to rulemaking. And then on the next slide, number 3 there, thank you. These are the tasks, we're going to go through a few of the task force recommendations, gap filling rules, anticipated, not really much on anticipated costs and benefits. And then questions, the fact that there are questions out there that they are asking for assistance with. So we've spoken about the task force. They went out and spent, it was very quick. It was a very quick one this time. It didn't take a year to do, it did a few months. But they did speak to over 110 stakeholders. So we're on slide 4 now. And got a lot of comments. I did manage to comment myself, but because I was on the OSC at the time, we weren't doing formal comments, so I just gave them to Wally. The CSA has provided their assessments. Now we're on to the next slide 5. They provided their comments as well. And then in January 22nd, 2021, there was a final report of that group that had 74 consequential recommendations to the minister. So it covered a lot of different areas. Because people, I mean, it was like open-ended. What do you want to talk about, everyone? The task force recommendations, now the next slide. The first recommendation was to introduce what was called a Capital Markets Act. So, so we're changing the name of the thing. In Ontario, that would be based, because it's not just securities even anymore. It's bigger than that. And could be based on the draft proposed Capital Markets Act developed by CCRN. That was the federal base body to replace the Securities Act. And it's also replacing the Commodities Futures Act. That act has been around for a long time and really needed to be brought together with securities so that we kind of have a more holistic way of dealing with derivatives and other areas. Consequently, an accompanying statute is being required. The task force suggested that the Minister of Finance work with the OSC towards implementing the Ontario version of the CMA by the end of 2021. They're, well, not quite on track. Next slide, please. Oh, sorry, one back. On October 12th, they released a draft Act, CMA we'll call it, and its first stage is only intended for stakeholder consultation purposes, and comments received will be considered prior to determining next steps. So the comment period for that is to January. Not going to meet the 2021 deadline, but we're moving along quite nicely. It will not become law unless a bill is passed by the Legislative Assembly in Ontario, and the CMA is new draft legislation intended to replace as I said, those two pieces. Moving to the next slide. The CMA draft sets up the regulatory framework. It outlines the OSC's regulatory and enforcement powers, including authority to make rules. It provides for what we're going to call the Capital Markets Tribunal. That's going to be split out to partially split out, adjudicative powers, and it will modernize the current capital markets legislation, retaining key components while introducing new elements to promote flexibility within a modern regulatory framework. And I should add, with regard to that split out of the tribunal, it means that it will still be reporting to the chair. I think I did mention that actually. Okay, and the reason for that is because when we looked at that, when we were looking at the National Securities Regulator, was because it had been tried, a complete split had been tried. You still stay on the slide 8, please. Had been tried in the UK when they did their big regulatory structure, again, 15 years ago, I guess it was almost. But they found, and they told us in Canada, that it doesn't work very well when you completely split out your tribunal, because it doesn't have that same kind of link to the fast-paced change in what the environment is. And therefore, you end up losing the specialization if you don't have your tribunal somewhat associated with the regulatory body. A very interesting case there. Okay, go ahead to slide 9. The drafts of the CMA, they align with the development and rapidly evolving sector, and that just ties it into the tribunal as well. Creates greater harmonization and ensures that the legislation is easily accessible and written in a language that can be understood, which is becoming a problem with the securities area generally. Next slide 10 is just a continuation on that, fundamental provisions. Let's go on to 11. This one here, reviewing, as I indicated, what we did with the Securities Act, Commission Act, and we'll go on to the next slide. Currently members, we're talking about the specialized tribunal there. The next slide we'll go to is 14, so 2 on. Okay. As I indicated down at the bottom of 14, it's been introduced. Yes, it's expected to be proclaimed into force in the coming months. Moving to 15, we have overview of what's going on, and we'll leave this with you to go through it in detail as you look at the Act itself. Slide 16. Wanted to talk a bit about recognized entities. The recognized entities part 2 outlines the requirements for recognized entities, including self-regulatory organizations, exchange, clearing agencies. The recognized agencies are exempt from recognition. If they're exempt, they have to comply with rules and conditions. And on the bottom of that page there, we refer to the chief regulator. So this is the party that's essentially going to be the person who is head of the tribunal. They're going to make, but the chief regulator can make recognition orders and decisions related to camera in front of me here, so I'll maybe stick with this. Restrictions and requirements on the recognition order, and provides that the OSC with the ability to exercise accountability over recognized entities. That was just a good one to keep attention to. Next slide, we're dealing with designated entities, and I'm going to run out of time, so I'm going to move on to slide 20. This is an overview of what the rules are going to be for distribution of securities. We're looking at, one of the things we're looking at is what are the requirements for securities distributions. We are trying to move towards, as an industry, I'm speaking, the royal we there, we are trying to move towards simpler disclosure. And here we talk about prospectus having to provide full, true, and plain disclosure of all material facts. We talk about a chief regulator issuing a receipt if the prospectus or document is filed in accordance with the rules, and considers that it's not, they can refuse to do a receipt if it's not in the public interest to do so. So that's just an important point there. What next couple slides are dealing with distributions of securities and dealing with trades and derivatives. Moving on to slide 23, we've got an overview on governance obligations. We've got takeover bids in 24. We've got further on 25, further on takeover bids, issuer bids, and that. So it's essentially taking the act that we have now and modernizing the language, trying to make it fairly easy to read, but also not really changing a lot of stuff in here. 25, we've got takeover bids, sorry, 26. And let's move on to 27, we've got the market conduct. 31, we're moving on to 31 and moving fairly fast again. A lot of stuff on market conduct and rewriting it so that it's just easier to read. Then going to 34, 33 and 34, we're talking about orders, reviews, and appeals. And I'm going to move quite a bit here. There's a lot of general stuff on that gives key differences, but I want to go to slide 47, which has key differences. And in that section, we do set out for you some of the stuff that sort of help you understand what's going on. The issue that it's platform approach, key differences in 50. Oh, sorry, just 49. We've got a picture. 49. Thank you. Okay, so that's the overlay of where the act is, and in 50 we're dealing with. I just want to do a couple key differences there. The next slide, please. If the CMA is enacted, the Futures Act will be repealed, and the futures contracts and options will be regulated as derivatives. So this ties into a similar kind of question that we have with the cryptocurrencies, and that as well. All these things are going to be regulated through one platform legislation. The registration exemptions of the Commodities Futures Act will no longer be available. However, a trade trigger for registration under that will replace the business trigger. So it's a similar kind of approach that we're taking on all sides. Moving on to 52, just wanted to highlight the different heads of authority that they have there and definitions and all that. The proposed new approach to rulemaking represents a modern approach in contrast to the more prescriptive approach currently used by the Ontario Securities Act. That's important. That's modernization. Moving to 55, we are going to reduce some interesting sort of governance issues. The regulatory process in Canada has been, it's quite lengthy. And so the plan here is to reduce the consultation time for rulemaking from 90 days to 60 days. Make it easier, actually, frankly, for those of us in the industry to remember what it is that we were looking at by the time we get around to trying to make the actual new rule. In 56 here, it's going to provide the OSC with additional tools for continuous disclosure and exemption compliance, and the power to make compliance orders. So the compliance power is going to be delegated to the staff of the OSC's corporate finance branch, which will allow for swifter compliance orders. And that will help as well, speed things up. In 57, we are moving to a well-known seasoned issuer model. And I'm sorry, you guys can tell me what I'm out of time here. Can you just check what my time is? We are going to be expanding on the civil liability. This one's kind of interesting. claims will be allowed to be made against a issue, not just an issuer, but directors and promoters of the issuer as well. I've got 5 more minutes. Okay, great. And that's quite interesting, because the idea is you don't want somebody getting away with it by hiding behind the issuer, but it's also a little bit dangerous the way that I think that's coming in. So comments on that are welcome, please. In number 60, we are going to provide the OSC with rulemaking authority to adapt prospectus liability to address regulatory gaps resulting from new and evolving financing structures. And so that will allow the CMA to broaden the civil liability and to expand the scope of liability to certain influential people. That's an interesting sort of word. Again, I would suggest you might want to take a look at that and see whether you have comments on it. And because where does that end, right? It can expand quite extensively. Under 61, I wanted to note the OSC has initiated enforcement proceedings against non-compliant platforms. I already talked about the cryptocurrency stuff. And as a result of that, it's interesting, a number of crypto assets been in the paper, Financial Post quite a bit lately. There are, some of them have actually just exited out of Ontario altogether because they aren't prepared to comply with that. In 62, we've got giving the OSC additional designation powers, and here I do note the last one. These designated powers and rulemaking authority include the power to designate crypto assets as securities and derivatives, and the power to prescribe crypto assets to be securities and or derivatives. So in Ontario, we are looking at them as securities, and you may have seen recently in the paper that the SEC is in some cases taking a different approach and not considering them to be securities. In 63, we've got the task force recommendations on the Capital Markets Act here, requiring public listed issuers to have an annual advisory shareholders vote on executive compensation. Interestingly, that is this new act has the ability to do that, but it's kind of controversial on the street, and it may not actually be coming into force. We'll see. I could talk about executive compensation for a long time, but no time for that today. 65, we've got the broader range of remedies. The tribunal will have the power related to M&A matters, more power there. That is, I'll try to help get through M&A matters more quickly. In 66, we have a prohibition to deter and prosecute misleading or untrue statements about public companies. And this is an interesting power. I think it's probably a good one that we want to add, that because what we have is we have some people, sometimes from not even in the country, will make statements, and then that causes the price to go down and allows for other people to come in and buy. And so there's been some fiddling around in marketplaces that I think they're trying to address in that one. Who's making money? That's what you always got to ask yourself. I'm going to go forward quite a ways here to 75. This creates a prohibition to prosecute front running effectively. And again, prohibiting front running allows the OSC to take enforcement action against this activity, enhancing confidence in the integrity of the capital markets. So some tweaking there to make them more efficient and less subject to being, shall we say, held up. Tab number 79 has the OSC will be able to share compelled testimony with a court-appointed receiver to facilitate returning funds to harmed investors. And that's really important for the role of the OSC in trying to get money back. It's when they get a fine in and they want to distribute it, but how do you get it back to the people that have been injured? This is a tool for helping with that. Part of the reason we have the OSC has money in a fund is now available to distribute to various investor protection privately done projects is because the OSC hasn't been able to get all that money back to people who are injured. In 81, we have 74 explicit exemption from freedom of information disclosures for whistleblower identifying information. So this is to make it, if you're a whistleblower and you want to go to the OSC and tell them about something that's going wrong, that's leading to prosecution, you want to make sure that your name isn't going to be out there, because you may never be able to get another job. So that's the purpose of that.
Heather, could I ask you to just wind it up now? So
Yep, I'm winding it up. Thank you. Consultations are due by January 21st, 2022, and I am done.
That's great. Thank you for that very extensive survey of all these changes, and your excellent presentation will be available. We're going to post all of our presentations on the website subsequent to the webinar. Let's turn now to our final, the saving the best for last, Lindsay and Parish on digital assets, please.
Thank you, Lorne. Nice to know that you've saved the best for last. This is, and thank you, Heather. That's, it's quite an overwhelming change. And, you know, we people who work in the tax area always lamented that it wasn't really fair, because, you know, we would have notice of ways and means motions and new draft legislation to review several times a year. But it seemed like the securities law and the Business Corporations Act never changed. So we sympathize. So this is a repeat of a program that we did actually just before COVID came along into our lives. And it was at our last live presentation of the Toolbox seminars. And this is a growing concern with estate planning and estate administration, and that is dealing with digital assets, planning for them, and then dealing with them on death. So the last time that we addressed this, I had one of our students assist me, because for the most part, the digital world is very much an exploding one. And I find that young people are well tuned into it. So we had a presentation done then, and I felt it was timely to address it again, because it's now over 2 years, I think, since we did our last presentation. And what we're finding is that it's becoming real. It was originally, there'd be articles in the newspaper about a case out of California where someone had an issue accessing digital assets when the loved one died. And there was all sorts of concern, because there could be value or there could be sentimental value. And I recently had my first case where the deceased had died suddenly, and her husband could not access the iPad, and the iPad had all family pictures on it, and he could not crack it with her password. So that prompted me to look into whether there'd been any progress in the law as to getting Apple to assist. And because historically, Apple had said, too bad, nothing we can do, it's gone. And lo and behold, another very bright young student who's going to co-present today, Parish Bhumgara, he researched and found that, yes, there was now a facility where one could go to court locally, not in California or any other jurisdiction, but in Ontario, and ask a judge to order that Apple release the password so the family could access the iPad. A very expensive proposition, however. So Parish has done some more research and updated the presentation from a couple of years ago. And with that, I'm going to turn it over to Parish to go through the current state, as we understand it, of the law, where there is some provision for digital assets, succession on death. And then at the end of Parish's presentation, I will at the end wrap up with some estate planning considerations that should be kept in mind. So with that, I'll turn it over to Parish. Thank you. So have we got Parish?
Parish, you're on mute. say something so we can hear you?
What about now?
Yes.
Okay, sorry, I just hit the wrong button. Yeah, so thank you, Lindsay. My name is Parish Bhumgara, and I'm an articling student at Gardner-Roberts. Just to give you a brief overview of what we'll be covering today, we'll start with a little bit of a prologue into digital assets. And then we'll go into defining and categorizing the difference between digital assets and digital accounts. And then we'll talk about various types of accounts, currency accounts, virtual property accounts, and social media accounts. We'll then proceed to summarize the law in Canada and discuss barriers to access. And as mentioned, Lindsay will then conclude with some estate planning considerations. So the most mainstream and popular example of a digital asset is probably Bitcoin. There are only 21 million Bitcoins available to be mined. And off that 21 million, we're getting close to now 19 million having been mined. Some sources estimate that as many as 3 million Bitcoins, which are worth about 38 billion, if not more now, are irretrievable. And this is due to lost retrieval codes like private keys, lost USBs where the only records are stored are on a USB key, and owner's deaths without leaving the private keys accessible to an executor or a next of kin. The cryptocurrency market itself is expanding. Wealthsimple CryptoCrade now offers 34 different cryptocurrencies on its investing platform. Some popular ones include Ethereum, Litecoin, Ripple, Cardano, and of course the meme frenzy Dogecoin. Another thing that has really come out lately is non-fungible tokens. And so this has expanded into other asset classes. Basically, a non-fungible token is a token stored on the blockchain, and blockchain itself is a secure distributed database with redundancy, immutability, and clarity into tracking data or ownership. And so basically a token proves ownership of an asset. So the same way as a deed to your house is a sign of your ownership over that plot of land in the building, the digital token is a sign of your ownership. And using Bitcoin as an example again, a single Bitcoin is the title to ownership of the underlying value of the Bitcoin. So where this has really become popular is with artists and pieces of art. So Mike Winkelmann, known as at Beeple, is a renowned artist who has worked with Nike and Apple. And he recently sold a collection of many of his works combined into a masterpiece titled Every Day is the First 5,000 Days for $69 million. And so what's crazy about this is there's screenshots available of his art, and his art's available online that you can just Google image search it. But the non-fungible token is kind of ownership that you own that picture of the art. So these transactions occurred on Ethereum, which is a blockchain. And so Winkelmann's art itself was simply digital images. And you might wonder why people then buy NFTs. From a monetary standpoint, it's feasible to collect royalties and resell the NFT in the future for profit. With the growth of virtual reality, such as Facebook's metaverse and things like that, potential applications could be actually licensing the image in the metaverse. And of course, that's just something we would never thought about many years ago. A bit more of a prologue, of course, the risk of cryptocurrencies. In December 2018, Gerald Cotton, who was a CEO of Quadriga CX, which at the time was Canada's largest cryptocurrency exchange, died suddenly at the age of 30. And unfortunately for many people, Mr. Cotton was the only person who had passwords to approximately 115,000 people's customers' digital wallets. And this represented approximately $140 million that was deemed inaccessible. And so auditors were able to find irregularities and retrieve about 33 million in missing funds. But of course, that still leaves over $100 million that has not been retrieved. This led to calls for the RCMP to actually exhume his body. And there's an interesting podcast on whether he faked his death or not. Now we can get into the defining and categorizing section. And so this is where we'll talk about digital assets versus digital accounts. And so classification is difficult because these assets and accounts are fluid and ever growing. A helpful way of thinking about it is a digital asset is a singular file. A digital account is a mechanism used to control and access the file. So a digital asset is the file itself. Photos, videos, blog posts, emails, documents, etc. You can see the examples on the slide. And so the potential value is in customer invoices, health and medical records, tax documents, and so forth. Digital accounts are used to access these files. Things like email accounts like Gmail, your Facebook account, other file sharing accounts, and software licenses. Of these digital accounts, they can be separated into 3 categories. So currency accounts, virtual property accounts, and social media accounts. Currency accounts are accounts that hold currency that can be converted into actual money. So PayPal, eBay, loyalty program accounts, cashback programs, and of course, cryptocurrency platforms like Wealthsimple. And these allow for transfer to heirs and beneficiaries when you pass. Virtual property accounts are accounts that hold digital content. So there's no actual ownership in the assets, just a license to use. So things like an iTunes music collection or a Kindle library. Contrast this with physical counterparts like CDs and physical books that we previously were accustomed to using. And so these licenses may not be transferable to heirs and beneficiaries, but this is, as Lindsay alluded to earlier, changing. Social media accounts are accounts that contain information likely of personal or commercial interest. And these are like email, Facebook, Instagram, the standard social media and email platforms. So what is the law in Canada concerning these? Generally, there's no general right of survivorship, meaning there's no federal or Ontario legislation on estate administration of a person's digital assets. Alberta is the only province that has legislation specifically ensuring representatives of a deceased estate have access to administer the digital assets. So the Uniform Access to Digital Assets by Fiduciaries Act was proposed in 2016 by the Uniform Law Commission. Basically, it will provide fiduciaries with default access to digital assets held by a deceased or incapable person. And it would not distinguish between types of fiduciaries. So they could be legal representatives, powers of attorney, or guardians. They would give them control over any digital asset, so any type of electronically stored information, including information stored on a computer or other digital device, content on websites, and digital property rights such as domain names and other material that the deceased may have created online. So the account holder would be the individual who has entered into a service agreement with a custodian. And a custodian is the person who holds, maintains, processes, and otherwise receives or stores a digital asset of an account holder. This is like the online service provider of Facebook or Gmail. So what this act would have done is given a fiduciary the ability to access, control, and copy the digital asset. So through a power of attorney, a trust, or a will, or a court order, you could be able to alter this default position. Any service agreement that limits the fiduciary's access will be voided unless the account holder accepts its terms and consents in a separate agreement. So not just blindly checking the terms and conditions box when you sign up for a Facebook or Gmail account. The other issue that this touches on is privacy laws. And so privacy rights continue after death, and custodians such as Facebook are governed by the Federal Personal Information Protection and Electronic Document Act. The exception is when does that act allow an organization to disclose personal information without that individual's consent? And so it does not compel custodians to disclose personal information in estate administration, which can make it challenging for loved ones trying to access photos and videos and other mementos from a deceased's account. Another barrier to access is the terms of service and the user agreements. So these tend to have restrictive policies. They may prohibit access to estate trustees, and they may deny estate trustees the ability to deal with content. So some specific examples are in virtual currency and e-commerce. Accounts such as Amazon, Bitcoin, and PayPal, or virtual property accounts such as Apple and Kindle, which are again licensed and not owned. Other accounts such as rewards points, Aeroplan, Air Miles, and of course, social media accounts such as Gmail, Facebook, and the like that we've talked about. So the problem is that no right of survivorship for digital assets, plus a lack of legislation, plus privacy-oriented terms of service and user agreements, leads to no immediate right to access, transfer, or delete online accounts of a deceased. So as we alluded to earlier, this is changing, however. Apple's website now alerts people that they can request a court order to obtain access to a deceased family member's account. I'm not going to run through all the information on the slide, but you can see that they give a detailed description of what exactly is required. And the whole reason Apple no longer opposes these orders is they just want their public image to be maintained, that they don't violate anyone's privacy willingly, and that you have to go through the proper legislative mechanisms to achieve that result. Facebook also has a facility where you can designate someone to access your account once you're deceased. It either gives you an option to remove the account or to memorialize an account, in which case it stays there and the loved one would be able to access and post on the behalf of the deceased. Gmail also now allows access by an alternative person. However, Gmail is still on the more restrictive side, as you can see from the quote on screen. They do say they'll work with members, but they always maintain the discretion to decide whether they want to grant access or not. And families will still have to jump through the hoops and provide the necessary paperwork in order to be given access. All of this is to say is that it's just very important to plan in advance and make sure that the executor or power of attorney or other person is given the plan and knows what it is. And with that, I'll turn it over to Lindsay.
Thank you, Parish. So, the planning considerations for digital assets is a moving target. One thing to remember and for executors to keep in mind is that these are assets that are subject to tax like any other asset. So they are subject to state administration tax. Query whether they could be transferred under the secondary will, a technique to avoid probate, paying probate tax. But tax on capital gain on death also applies to these digital assets. So something like Bitcoin, if the individual acquired it early and it's worth a lot now. The challenge, of course, is for the taxing authorities to catch up to people who own these assets because they are virtual. But bear in mind, the executor is personally liable for taxes of the deceased to the extent of the estate assets. So the compliance becomes very important when an individual passes away and has owned significant virtual currency. Generally, digital property will vest in the executor and the personal representative, just as any assets of the estate do. But access to the digital property is typically a real challenge for the estate trustee and the family. So, for example, these cryptocurrencies, which are accessed by virtual wallets, and they need a private key and nobody knows what the private key is. Or if it's in a password protected electronic device, this can also prove extremely challenging to access. Next slide, please. So we know that it's possible to store things like Bitcoin on digital wallets, and there's also websites that offer to store the passwords, but the websites where you store your passwords also are password protected. And so it's possible to lose a Bitcoin wallet or to delete the Bitcoins and lose them forever. There's also been hackers who have stolen Bitcoins from websites. So, this services that provide remote storage are not fail-proof. And because owners are reluctant to give anyone the access codes, even loved ones, it can make it very challenging to access. So I had a young man who I was doing a will for. He was only 18 years old, but he had Bitcoins and he wanted to leave them to his girlfriend. And I asked him where he stored them, and he looked at me in the face and he said, "On my person." And I kind of thought, oh, okay, what are these worth? Oh, about $10,000. And I said, so you're storing them with you? And he pulled out his USB, and this was his storage for his Bitcoin. And it was encrypted, password protected. And he felt the safest thing to do was to keep it on him at all times, because he did not trust that if he left it anywhere on the web, it would be safe. So I said, well, what if you lose your USB? It's like losing, $10,000 out of your wallet. However, that's the age we're in. Next slide, please. The next slide, please, Parish. Thanks. So for estate planning, some of the obvious steps to consider is that the will should address the disposition of digital assets if they're of significant value. The will should also provide the executor with specific authorization to access digital assets, usernames, and passwords. So I don't think I actually annexed the clause to the overhead slides for today, but it will be on our website attached to the presentation later. And I just have a standard clause that I'm actually now putting in powers of attorney as well, that to the extent you can, authorizes the executor all this access. But again, the service provider may still have rules where they will not allow the executor, even with a probate or a power of attorney, to access the information. So there's challenges for an executor. And one of the big ones is in Canada, Bitcoin's not traded on any stock exchange. So where does one locate and realize the cryptocurrency? There's this company, CoinCover, for example, that's created what it describes as one of the world's first cryptocurrency wills. Again, it's password protected, etc. And I really don't have any experience with this particular facility, but it's definitely a sign of the times. They advertise an indestructible card, which has information about the client's cryptocurrency. So it's sort of like a plastic credit type card. And if the client dies, the executor contacts CoinCover with a unique number that's on the card and a death certificate, and then presumably they can access the information. Next slide, please. So another issue that's come to light is the clarifying the source of the funds that were used to buy the cryptocurrency in the first place. And I saw an article recently where a lady in Israel who had bought Bitcoin in 2008, I believe, now she bought it for $3,000 and her Bitcoins were now worth $1 million. And so she was trying to realize on the Bitcoins and have the money deposited in her bank account. But the bank refused to deal with her because she couldn't prove the source of the original Bitcoin acquisition. It was cash. And because institutions are so very seriously concerned and subject to legislation that deals with money laundering, proceeds of crime, et cetera, she wasn't able and hasn't been able to actually realize on her investment. And next slide. So this is just for fun. This is off the Amazon.ca website that shows you can buy CoinCover cryptocurrency will kit. This is not an endorsement. It's a source of amusement right now, but it may become mainstream. And the next slide. So this is for my young man who kept his Bitcoin on his person. This is again, Amazon advertising a Bitcoin wallet, USB, and with a lanyard. So, wear it around your neck, wear it into the shower maybe so you don't lose it. In any event, again, this is not an endorsement. So we will continue to update as time goes on and we learn more about this new emerging asset of individuals and estates and how to deal with it. But my best advice always is that write it down the old-fashioned way, what the passwords are, and share it with your loved ones. I have 2 books here. I will hold them up so you can see them. They look like journals, but what they are password keepers. And this is becoming a thing. Again, you can go onto Amazon and buy these password keeper books. They deliberately don't say on the front of them password keeper. And the idea is write your passwords down. Again, presuming it's not illegal to do so, because some of the providers make it illegal to share your passwords. So you don't necessarily have to share it, but if you keep it in a safe place and let your executors or your loved ones know where to access it in the event that there's a death or incompetency or any other emergency, it can really be a godsend. Personally, I am doing this now. I'm writing them down, and I find it very useful because I tend to forget what my passwords are when I haven't logged into a website for a while. But again, the idea is to keep it in a very secure place so it can't be abused. That is the most best advice, old-fashioned advice that I can give right now, so that if something were to happen, people can actually get into the iPhone, the iPad, and all the other websites where the individual may have been dealing. So thank you, Parish, for co-presenting, and that's the end of my presentation.
That's great. I want to thank all of the speakers for the excellent presentations. We've got some very dense slides and so on, which we'll make available on the website after. We are almost at the 1:30 time. We promised to end it after an hour and a half. So we have a brief period of time. If there are any questions, we'd be happy to take them now, or you can email the questions to us, and the appropriate speaker will respond. There don't seem to be any questions, so I'm going to wrap it up for 2021 and hope that the next time that we get together, it won't be as limited as we have now. Hopefully we'll see the beginning of the end of this pandemic. We're not there yet, but we're on the right path. So everybody get vaccinated, get your boosters, stay healthy, and we hope to see you at least virtually in 2022. Goodbye for today.